Hello again, everyone. Prosecutor Fabrica here. Today we are going to discuss the last part of Book 1, which is Extinction of Criminal Liability, with some discussion on civil liability. As usual, I will start my discussion with this disclaimer that this is merely a supplement to your study of criminal law. It does not seek to supplant your reading materials nor contradict what your professors have discussed to you about the subject matter. And of course, this is not an attempt to present myself as an expert in the field, but merely to share my knowledge of criminal law, drawing from my experience as a prosecutor for the last 11 years. What are the causes of total extinction of criminal liability under Article 89? First is death of the accused or death of the convict. Second, service of sentence. Third, amnesty. Fourth, absolute pardon. Fifth, prescription of the crime. Sixth, prescription of the penalty. And last is marriage of the offended woman under Articles 266-C and 344 of the Revised Penal Code. Don't you worry, we will discuss or attempt to discuss all of them one by one. And we also have the causes of partial extinction of criminal liability under Article 94. We have conditional pardon, commutation of sentence, and good conduct time allowance under Republic Act 10592, amending Articles 97 and 98 of the Revised Penal Code. So let's start with the first cause of total extinction of criminal liability, which is death of the convict. Death of the person or respondent or accused or convict, whatever you may call him, extinguishes his criminal liability, although the provision itself merely talks about convict, but I dare to include person, respondent, and accused because the moment a person dies, he can no longer be charged with an offense. So even if he is still a respondent or even if he is not yet charged, let's say he commits a crime and then he's not yet charged. The moment he dies, no case can be charged against him. So the effect affects not just the convict but the person himself who commits a crime. So, as I said, it extinguishes his criminal liability. Example, X raped Y. The following day, X died. No case can be filed against X. Example 2, X raped Y. Y filed a complaint for rape against X in the Fiscal's office. The following week, X died. The complaint against X will be dismissed. Example number 3, X raped Y. While the case against X was pending trial in court, X died. Here, the case against X will also be dismissed. So, these examples exemplify what I was talking a while ago, that the death of the person himself who commits the crime, whether he is already charged or he is not yet charged of the crime, extinguishes whatever criminal liability he may have. Example number 4, X raped Y. X was convicted of rape. While X was serving sentence at the New Bilibid prisons, X died. Here, his criminal liability is extinguished because imprisonment as a penalty requires personal service of sentence. How can a dead person still serve sentence? Right? Question. What about excess civil liability? Because the examples I have given talk about extinction of excess criminal liability. So there's no more argument to that. But what about excess civil liability? will it also be extinguished by his death? The answer is his civil liability shall be extinguished if his death occurs before final judgment. So take note of the underlined portion there. To repeat, excess civil liability will only be extinguished if his death occurs before final judgment. What do I mean by this? Example number 1. X raped Y. While X's case was pending trial, X died. Here, his death extinguished both his criminal and civil liability. Why? Because his death occurred before final judgment. Example number 2. X raped Y. The court convicted X of rape. 3 days after his conviction, X died. Here, his death extinguished also both his criminal and civil liability. Why? Because while there may have been a judgment of conviction, his conviction is not yet final. Example number 3. X was convicted of rape. X died while his case was on appeal. Here, his death extinguished both his criminal and civil liability also because in the same or for the same reason, his conviction is not yet final. Why do I say that his conviction is not yet final? Because 3 days after the conviction is not yet final because it takes 15 days. Okay, generally speaking, it takes 15 days from the date of the promulgation of judgment wherein his conviction or the conviction of an accused becomes final. After 15 days without the accused filing a notice of appeal or filing an application for probation, for example, the decision of the court convicting him becomes final. So in this case, since X died 3 days after the conviction, it obviously follows that his conviction at this instance is not yet final. And same goes with the situation where X appealed his conviction. So if X appealed his conviction, it presupposes that his conviction by the lower court is not yet final because X wants the next higher court to reverse his conviction. Example number 4. X was convicted of rape. He did not appeal his conviction within 15 days from promulgation, such that the judgment of conviction became final. That's what I was talking about earlier. Thereafter, X died. Here, his criminal liability is extinguished, but his civil liability subsists. Reason? X's death occurred after final judgment. Take note of that. Example number 5. X, after he was convicted, applied for probation. Thereafter, X died. Here, his criminal liability is extinguished, but his civil liability subsists. Reason? The mere filing of an application for probation amounts to a waiver of the right to appeal, which makes the judgment of conviction final. Do you remember I discussed probation law in one of my videos, so please review that. Example number 6. X, after he was convicted, waived in writing his right to appeal. Thereafter, he died. Result or reason? Same result as examples 4 and 5. Okay? Meaning to say, his civil liability subsists. Example number 7. X, after he was convicted, appealed his conviction but later on withdrew his appeal, which the court granted. Thereafter, X died. Same result as examples 4, 5, and 6. Meaning to say, his civil liability subsists because his death occurred after final judgment. Now, a judgment becomes final, number 1, after the lapse or Let me paraphrase it. A judgment becomes final under any of the following instances. Number one, after the lapse of 15 days from promulgation of judgment. Or, number two, when the convict files an application for probation. Or, number three, when the convict waives in writing his right to appeal. Or, number four, upon the grant of the withdrawal of the appeal. What does criminal liability entail? Answer: it entails service of the principal and accessory penalty. Since we are talking about extinction of criminal liability, meaning the criminal liability will be erased, we must first review what criminal liability is. So I am answering my own question. What does criminal liability entail? It entails service of the principal and accessory penalties as the case may be, as provided for in Article 25. Again, Article 25 is the scale to use when determining what are principal and accessory penalties. And when I say it entails service of the principal and accessory penalties, you have to go to the specific penalties attached to the specific crimes mentioned in the revised penal code. There you will find the penalties which I am talking about and which are based in Article 25. Talking about civil liability, what is the basis of civil liability arising from crime? The basis is found in Article 100 of the revised penal code, which states, every person criminally liable for a felony is also civilly liable. Reason for providing civil liability arising from crime is that a crime has a dual character in that, number one, it is considered as an offense against the state. That's why a person who commits a crime will be meted the penalty of either imprisonment or fine, usually. That is called criminal liability. And at the same time, every time a person commits a crime, it is considered as an offense against the private person injured by the crime. So that is, in short, what we call civil liability. Take note that not all crimes have a component civil liability attached to it, such that even if the accused is convicted, no civil liability arises either because, number one, there is no private offended party like in victimless crimes. For example, the crime of illegal gambling, that is a victimless crime because there is no private offended party there. The only offended party there is the state. Or number two, there are no damages to be compensated even if there is a private offended party. Okay, like for example, in the crime of maltreatment, when maltreatment is considered as a form of slight physical injury, when there is no injury caused on the body of the victim or caused to the body of the victim, then there is no damage to be paid, okay, by the accused. There is no reparation, so to speak, of the damage because there is no damage in the first place, although the accused is convicted of the crime for his act of maltreating the other person. What does civil liability include? It includes, number one, restitution. Number two, reparation of the damage caused. Number three, indemnification for consequential damages. So this is based in Article 104 of the revised penal code. The first remedy is, as I said, restitution of the thing taken by the offender. So restitution applies mostly in crimes against property, for example, in theft or robbery. So the offender, if convicted, has the civil liability or obligation to return the thing taken by him and give it back to the victim or to the owner. So that is what is called restitution of the thing. Now, If restitution by the offender or his heirs is no longer possible, then the second remedy is reparation of the damage caused. So if the thing stolen can no longer be returned, then the offender must pay for the value of the thing stolen. That is reparation. In either case, there should be what? Indemnity for consequential damages. Now, in restitution, like what I said, the convict must return the thing stolen or taken. In reparation, in case the restitution cannot be made, this is again a repetition of what I said just a while ago, the offender must pay for the thing stolen or taken, or in case of physical injuries, reparation entails payment of expenses made for the victim's treatment. In indemnification, it shall include not only those caused to the victim, but also those suffered by his family or by a third person by reason of the crime. So, for example, if because of the crime, another person got injured, the offender is obliged to pay civil liability to the third person injured, although that person was not the primary victim or was not the intended victim. He is still liable for the injury caused to that person. Or indemnification for consequential damages could also mean indemnification for loss of income. For example, if the offender, because of the crime, rather the offended because of the crime was not able to go to work for a certain period, the offender here is obliged to pay for the number of days when the offended party, the victim, was not able to go to work. So he must indemnify for the victim's loss of income. There is no question that every person criminally liable is also civilly liable pursuant to Article 100. Now, what if the accused is acquitted? Does his acquittal mean that he is also not civilly liable? The answer is it depends. Why? Because if he is acquitted based on pure innocence or on the ground that he is not the author of the act or omission complained of, then he is not civilly liable also. If he is acquitted based on a justifying circumstance like self-defense, then he is also not civilly liable because it is as if he committed no offense or crime. If he is acquitted on reasonable doubt, this time a civil action for damages for the same act or omission may be instituted by the victim pursuant to Article 29 of the new Civil Code. For example, the accused was tried for the crime of attempted murder, but his guilt was not proven beyond reasonable doubt. While his guilt may not have been proven beyond reasonable doubt, his culpability could still be proven in a civil case for damages by mere preponderance of evidence based on the same act or omission of the offender. So this is the rationale why a civil action can still be had even if the accused is acquitted on reasonable doubt. The quantum of evidence required in criminal cases is higher, which is proof of guilt beyond reasonable doubt, whereas in a civil case, it is not so high. No, it is lower than the quantum of evidence required for criminal cases, which is mere preponderance of evidence. So there is still a possibility that the victim may be able to prove the culpability of the offender in the civil action. If the accused is acquitted or the case against him is dismissed based on an exempting circumstance under Article 12 of the Revised Penal Code, like for example insanity, meaning to say the accused was insane at the time of the commission of the crime, or the accused is a child who is 15 and below at the time of the commission of the crime, or if the accused is a child who is above 15 but below 18 who did not act with discernment at the time of the commission of the crime, or if the accused is a person who acted under the compulsion of an irresistible force, or he acted under the impulse of an uncontrollable fear. These are exempting circumstances which will still make him civilly liable even if he is exempted from criminal liability. Another is when the accused is acquitted in the criminal action for negligence. He may still be held civilly liable for damages under Article 2177 of the New Civil Code on the theory that the act is a quasi-delict. Another is when the accused is acquitted because the court has determined that there is only civil liability, or in cases of independent civil actions under Articles 31, 32, 33, and 34 of the New Civil Code, the accused may still be held civilly liable. When you say independent civil actions, it can proceed independently, or they can proceed independently of the criminal action. So the cause of action here is not dependent on the act or omission complained of as a felony. So, for example, in the case of Article 33, let's say the victim has filed a case for physical injuries against the accused, criminal case. The victim may opt to file an independent civil action for damages for the same physical injuries. But in such event, the victim cannot claim from both actions, meaning to say, if the court has determined that the accused should be held civilly liable, let's say if in that criminal case, the court convicts the accused, and as you already know, for every criminal liability, there is also a corresponding civil liability under Article 100. So if the court has already adjudged damages in that criminal action, the victim who filed an independent civil action for damages in Article 33 can no longer claim damages from that same act or omission. Let's now go to service of sentence. Service of sentence is also a total, one of the causes of total extinguishment of criminal liability. The sentence, if it be one of imprisonment, must be served inside a penal institution, unless he is on probation or he was granted parole after serving the minimum term of imprisonment pursuant to the indeterminate sentence law. The period during which the convict evaded the service of his sentence is not included in the service of his sentence. Now, the only sentences that can be served outside of prison are when the penalty is destierro under Article 87, or when the penalty is arresto minor in Article 88. The judge here in Article 88 has the discretion to impose a penalty of imprisonment to be served at the house of the convict under the surveillance of an officer, taking into consideration the health of the offender and other justifiable reasons. Let's go to the next two causes of total extinguishment of criminal liability, which is amnesty on the one hand and absolute pardon on another. So let's compare the two. In absolute pardon, it is granted by the President for ordinary crimes like murder, robbery, theft, etc. Okay? Second, it is an act of grace of the President which is exclusive because it does not need the concurrence of Congress to be effective. Also, in absolute pardon, it relieves the offender from the consequences of the offense of which he has been convicted. Meaning to say, he will no longer be imprisoned. If he is in prison, he will be released. But the effects of the conviction will remain because in Article 36 of the Revised Penal Code, it states that a pardon shall not work the restoration of the right to hold public office or the right of suffrage, unless such rights be expressly restored in the terms of the pardon. Also, that a pardon shall in no case exempt the culprit or the offender from the payment of the civil indemnity imposed upon him by the sentence. So it only relieves him of the imprisonment aspect. And take note of this. In absolute pardon, it is only granted after final conviction, meaning conviction by final judgment. It will never be granted before the conviction becomes final. Let's go to amnesty. Amnesty, on the other hand, is granted by the President to classes of persons who may be guilty of political offenses. So if you remember the most popular political figure who was granted amnesty, make a guess, Trillanes. In the past, he was granted amnesty, and it was granted, I think, by uh, no less than President Aquino. Okay, so also in amnesty, while it is also an act of grace of the President, but it is not exclusive because it needs the concurrence of Congress to be effective. And the effects of amnesty are such that it abolishes and puts into oblivion the offense itself. The person released by the amnesty stands before the law precisely as though he had committed no offense. And number 4, amnesty, unlike absolute pardon, may be granted even before conviction, or it may be granted after final conviction. It may be granted anytime. Let's go to the next cause of extinguishment, total extinguishment of criminal liability, which is prescription of the crime. Now, prescription of the crime is the loss of the right of the state to prosecute an offender after the lapse of a certain period. So, for prescription of the crime, you have to distinguish if the crime is a felony under the RPC or if the crime is an offense punished under special laws. So if the crime is a felony or felonies under the RPC, for felonies punishable by death, reclusion perpetua or reclusion temporal, it prescribes or they prescribe in 20 years. I'm talking about, to repeat, felonies under the RPC. For felonies punishable by afflictive penalties like prisión mayor or perpetual or temporary absolute or perpetual or temporary special disqualification, it prescribes in 15 years. For crimes punishable by a correctional penalty like prisión correccional, suspension, or destierro, it prescribes in 10 years, with the exception of those punishable by arresto mayor, which prescribes in 5 years. For the crime of libel or other similar offenses, it prescribes in 1 year. And for the crime of oral defamation and slander by deed, it prescribes in 6 months. Lastly, for light offenses, it prescribes in 2 months. Now, what about for felonies punishable by fines, either imposed as a single or as an alternative penalty? You have to remember that for felonies punishable by fines, fines are either afflictive, correctional, or light, as follows. Basis is Article 26 of the Revised Penal Code, when afflictive, correctional, or light. A fine, whether imposed as a single or as an alternative penalty, shall be considered an afflictive penalty if the fine exceeds 1.2 million pesos. A correctional penalty if it does not exceed 1.2 million pesos, but is not less than 40,000 pesos. And it is considered a light penalty if it be less than 40,000 pesos. Take note that if a fine as an alternative penalty is higher than the other penalty, which is imprisonment, based upon Article 26, then the prescription of the crime should be based on the fine, not on the imprisonment or the penalty of imprisonment. Now, for offenses under special penal laws or municipal ordinances, the special penal law or the ordinance concerned provides for the prescriptive period. However, if the special penal law or the ordinance does not so provide for the prescriptive periods, Act number 3326 as amended shall govern as follows. So under Act number 3326, if the special penal law concerned or the municipal ordinance concerned does not so provide for the prescriptive periods, then in Act number 3326, for offenses punished only by a fine or by imprisonment of not more than 1 month or both, the prescriptive period is 1 year. For offenses punished by imprisonment of more than 1 month but less than 2 years, the prescriptive period is 4 years. For offenses punished by imprisonment for 2 years or more but less than 6 years, the prescriptive period is 8 years. For offenses punished by imprisonment for 6 years or more, the prescriptive period is 12 years. For offenses under the Internal Revenue Law, the prescriptive period is 5 years. For violations of municipal ordinances, the prescriptive periods or the prescriptive period is 2 months. So please remember that. And for violations of the regulations or conditions of the Certificate of Public Convenience by the Public Service Commission, the prescriptive period is also 2 months. Now, this is very important, when does the period of prescription of the crime begin to run? Because we already know that, like for example, in an afflictive penalty or when the penalty imposable is death or reclusion perpetua, the prescriptive period is 20 years. The question is, when does the prescription start? It depends because if the crime is punished under the revised penal code, it commences to run from the day on which the crime is, quote and unquote, discovered by the offended party. Second, by the authorities or their agents. Discovery by other than the persons enumerated will not start the running of the prescriptive period. Example number 1. X killed Y. Z, a neighbor, witnessed the killing but kept silent. It was only after 22 years that Z divulged to the authorities. Here, the authorities can still file a complaint because it was only from that moment when Z informed the authorities that the authorities is deemed to have discovered the crime. Example number 2. X stabbed Y multiple times but survived. Y kept silent for 20 years. On the 21st year, if Y decides to file a complaint against X, the same will be dismissed on the ground of prescription of the crime. Why? Because the date of the supposed discovery happens also to be the date of the commission of the crime. It was Y himself who discovered the crime because he is the victim. But he kept silent. He did not complain before the authorities such that After 20 years from the date of the commission of the crime is deemed to have prescribed. Example number 3. X committed the crime of rebellion by taking up arms against the government, being a member of the NPA. Being a continuing crime, and for as long as X continues to be a rebel, the period of prescription never begins to run, and the authorities may file a complaint against X anytime. However, if X surrenders and returns to the fold of the law, prescription begins to run. Now, when does prescription of the crime begin to run if the crime is punished under special penal laws? Answer: the period of prescription begins to run according to what is provided in the special penal law itself. If the special penal law does not so provide as to when prescription of the crime begins to run, then Act number 3326 governs, which provides that prescription begins to run from the day of the commission of the violation of the law, and if the same be not known at the time, then from the discovery thereof. Discovery by whom? Since Act number 3326 is silent on this point, Article 91 of the Revised Penal Code should apply suppletorily, which means that the discovery should be limited to the offended party, the authorities, or their agents. Next question. How is the period of prescription of the crime interrupted? It depends, because if the crime is punished under the Revised Penal Code, it shall be interrupted by the filing of the complaint or information, or when the offender is absent from the Philippines. Now, mere filing before the prosecutor's office for purposes of preliminary investigation is enough. It doesn't need to be filed in court for purposes of interrupting the period of prescription of the crime. In the case of the term absence, or when the offender is absent from the Philippines, the absence there must be for a long period of time. Okay? If the accused was merely vacationing or merely went to another country for a vacation and then after 3 weeks the accused came back, then that cannot be considered as an interruption. Now, if the crime is punished under the special penal law or under special penal laws, if the special penal law itself provides for the rule when prescription is interrupted, that special penal law governs. Otherwise, if it is not so provided in that special penal law, Act number 3326 governs. Said law provides that it shall be interrupted only when judicial proceedings are instituted against the guilty person. When you say only when judicial proceedings are instituted against the guilty person, it means filing of the complaint or information in court. Mere filing before the fiscal's office will not stop the running of the period of prescription. An exception where mere filing before the fiscal's office or before the office of the ombudsman is enough to interrupt the running of the prescriptive period is when the same involves corruption cases. This was taken from the case of Panagiton Jr. versus the DOJ. Also, unlike in felonies punished under the Revised Penal Code where the absence of the offender likewise interrupts the running of the prescriptive period, the absence of the offender in offenses punished by special penal laws will not interrupt the running of the said period. Next question. When does the period of prescription of the crime begin to run? Or begin to run again? If the crime is punished under the Revised Penal Code, It shall run again when, number one, the proceedings terminate without the accused being convicted or acquitted, or number two, the proceedings are stopped for any reason not imputable to the accused. Example number one. The complaint against X for slight physical injuries was dismissed by the prosecutor on the ground that the complaint had not yet undergone barangay conciliation under the Katarungang Pambarangay Law. Here, the period of prescription runs again because the dismissal is neither a conviction nor an acquittal. Example 2A. An information for rape was filed in court against X. After trial, X was acquitted on the ground that his guilt had not been proved beyond reasonable doubt. Or, same example, but this time X was convicted. In both instances, prescription is immaterial because whenever the accused is acquitted or convicted, he can no longer be charged of the same offense or for the same offense, meaning to say no person shall be put twice in jeopardy of punishment for the same offense. Example number 3. X was charged in court for rape, but the case could not proceed because X has yet to be arrested. Here, the prescription does not begin to run again because the proceedings or the proceeding was stopped due to a reason imputable to the accused. Now, for crimes punished under special penal laws, if there is no provision in the special penal law providing for a rule when prescription begins to run again, Act number 3326 governs, which provides that it shall run again if proceedings are dismissed for reasons not constituting jeopardy. The rule, therefore, is the same as in the revised penal code. Question: what about for situations where the proceedings are stopped for any reason not imputable to the accused? This time, Act number 3326 is silent on this, hence by supplementary application, the rule in the RPC applies. Let's go to the next cause of extinguishment of criminal liability, which is prescription of the penalty. The previous one was prescription of the crime. Now we have prescription of the penalty. What is prescription of the penalty? It is the loss of the right of the state to enforce the sentence imposed on the convict by the lapse of time. Penalties imposed by final sentence prescribed as follows. For death and reclusion perpetua, the prescriptive period is 20 years. For reclusion temporal, prisión mayor, and disqualification, 15 years. For correctional penalties, like for example, prisión correccional, suspension, or destierro, the prescriptive period of the penalty is 10 years, with the exception of the penalty of arresto mayor, which prescribes in 5 years. For light penalties, meaning those penalties which are imposed the penalty of arresto menor or public censure, the prescriptive period is 1 year. Now, the judgment imposing the penalty must have become final. If the convict has appealed his conviction, the sentence is not yet final. There is as yet no prescription of the penalty to speak of. Here are the elements of prescription of the penalty. Number 1, the penalty is imposed by final sentence. Number 2, the convict evaded the service of his sentence by escaping during the term of his sentence. Number 3, that the convict has not given himself up or been captured or gone to a foreign country where there is no extradition treaty between our country and said foreign country. Number 4, the penalty has prescribed because of the lapse of time from the date of the evasion of the service of sentence by the convict. Example number 1. X was convicted of murder. The court imposed upon X the penalty of reclusion perpetua. A year after serving sentence, X escaped and went into hiding. 21 years after his escape, X resurfaced. Here, the penalty has prescribed. Example number 2. Same example, but X escaped before he could serve sentence. Here, the penalty imposed on him will not prescribe even if he is captured 25 years after his escape because the escape did not take place while serving sentence. Now, to evade the service of sentence means number 1, the offender is a convict by final judgment. Number 2, he is serving his sentence, which consists in deprivation of liberty. And number 3, he evades service of sentence by escaping during the term of his sentence. Example 3. X was convicted and imposed a penalty of prison correctional. 1 year after serving sentence, X escaped and remained at large for 5 years. X was captured. He again escaped and went into hiding for 6 years. In case he is captured again, X can no longer be required to serve the remaining portion of his prison term because the penalty had already prescribed. The penalty of prison correctional prescribes in 10 years. The total number of years that he evaded sentence is 6 years, so more than a year. Example 4. Same example as number 3. After escaping, X went to a foreign country with which the Philippines has no extradition treaty. Here, the period of prescription of the penalty will be interrupted. It will run again if he comes back to the Philippines. Example number 5. Same example. X went to a foreign country with which the Philippines has an extradition treaty. Here, the period of prescription of the penalty will not be interrupted or will continue to run. Example number 6. Same example, but the crime committed by X is not included in the extradition treaty. This time, it will interrupt the period of prescription of the penalty. It is as if X went to a country with which the Philippines has no extradition treaty. Example number 7. If X commits another crime before the expiration of the period of prescription of the penalty, such prescription will be interrupted. Although evasion of service of sentence is itself a felony because it is defined and penalized in Article 157, there must be another crime committed in order to interrupt the period of prescription of the penalty. Now, the last cause of total extinguishment of criminal liability is the marriage of the offended woman under Articles 266-C and 344 of the Revised Penal Code. Article 266-C provides that the subsequent valid marriage between the offended party shall extinguish the criminal action or the penalty imposed. In case it is the legal husband who is the offender, the subsequent forgiveness by the wife as the offended party shall extinguish the criminal action or the penalty, provided that the crime shall not be extinguished or the penalty shall not be abated if the marriage is void ab initio. On the other hand, Article 344, last paragraph, states that in cases of seduction, abduction, acts of lasciviousness, and rape, the marriage of the offender with the offended party shall extinguish the criminal action or remit the penalty already imposed upon him. The provisions of this paragraph shall also be applicable to the co-principals, accomplices, and accessories after the fact of the above-mentioned crimes. For a thorough discussion on this, please see my discussion in the previous video, the video where I discussed Articles 21 to 23 at the 27th and 31-second minute mark. Now, for partial extinction of criminal liability, we have conditional pardon, commutation of sentence, and good conduct allowance. Let us discuss each of them. For conditional pardon, it is a contract between the president and the convict that the former will release the latter subject to the condition that if he does not comply with the conditions of the pardon, he will be recommitted to prison to serve the unexpired portion of the sentence. The president alone determines if the pardonee has violated the conditions of his pardon. It is not subject to judicial review. The conditional pardon, if one is given, just like the absolute pardon, does not extinguish the pardonee's civil liability arising from crime. For commutation of sentence, it is a change in the sentence made by the president, either by lowering the term of the sentence or changing the nature of the sentence itself. Here, the consent of the convict is no longer necessary. Why would the convict oppose in the first place? Now, with respect to good conduct allowance under Article 97, it states that the good conduct of any offender for as long as he qualifies for preventive imprisonment in Article 29, meaning to say he is not a recidivist or he is not a person who was convicted previously twice or more for any crime, or he is not one of those who failed to surrender voluntarily upon being summoned for the execution of his sentence, or he is not a habitual delinquent, he is not an escapee, or he is not charged with a heinous crime, meaning to say he qualifies for preventive imprisonment under Article 29, the good conduct or his good conduct shall likewise entitle him to the following deductions from the period of his sentence. For the first 2 years, the good conduct time allowance is 20 days per month. And then it increases. From the 3rd to the 5th year, it will be 23 days. From the 6th to the 10th year, 25 days. And then from the 11th year onwards, it will be 30 days per month. So let us further understand this by way of example. Here, X was convicted of homicide to which he was sentenced to an indeterminate penalty of 8 to 13 years. Let us suppose X had been preventively detained for 8 years. After 2 years of serving sentence for his conviction, he is entitled to the following deduction from the period of his sentence. So, 8 years is the number of years he was preventively detained. So, he is entitled to a deduction. Why? Because under Article 29, the period of his preventive detention will be credited in his favor, provided he is not disqualified, like what I explained a while ago. And then he had already served 2 years of his conviction, so 8 years plus 2 years. And then what about the 480 days? How did I get 480 days? 480 days represents the good conduct time allowance he has earned for the first 2 years. And why did it reach 480 days? Diba? 20 days per month. And how many months are there in a year? 12. How many months are there in 2 years? 24. So you multiply 20 days by 24, you will get 480 days. So summing it all up, 8 years plus 2 years plus 480 days you will get 11 years, 3 months, and 25 days. Now, this will increase until it reaches the maximum of his sentence. What is the maximum of his sentence? 13 years, which will then qualify him for immediate release if the time comes when the number of years of his preventive detention plus the number of years he has already served sentence plus his good conduct time allowance reaches the maximum of his sentence. Okay? So, even if in actuality he has not fully served his sentence, but because of the number of years he was preventively detained, plus the number of years he had started to serve sentence, plus the good conduct time allowance, if it reaches the maximum term of his imprisonment, then it will then qualify him for immediate release. So this is so beneficial on the part of the convict. Okay? So that ends my discussion on total and partial extinction of criminal liability with some discussion on civil liability. Thank you and looking forward to posting other topics or a new set of topics in the future. And of course, before you turn off your gadgets, please like, subscribe, and share. No? Para naman ma-inspired ako. Thank you.